In the late 19th century, America was at a critical juncture, grappling with the integration of post-slavery society. A landmark decision in this journey was the Supreme Court ruling in the case of Plessy v. Ferguson, which took place in 1896. The ruling laid out the doctrine of separate but equal, allowing racial segregation in public facilities, including railroads, to persist within the bounds of constitutional legality. This essay offers a nuanced exploration of the case, delving into the intricacies of the justices' opinions, the dissonances in their reasoning, and the societal influences that shaped their judgment. It argues that the court's decision, though purportedly rooted in constitutional principles, was more influenced by prevailing societal norms and the political landscape. The case's legacy, particularly its profound impact on the subsequent proliferation of Jim Crow laws, is examined in light of both the original intent of the 14th Amendment and the complexities of the justices' interpretation. The judicial rationale and dissenting opinions are scrutinized to reveal a landscape of contradictions and complexities that tell a broader story about race, law, and society in America. Plessy v. Ferguson, a reflective examination. During the 1890s, a time when the wounds of the Civil War were beginning to heal, the collective memory of the populace seemed to obscure the once vivid animosities stirred by the conflict. This rapid transition was nurtured by political leaders' fervent desire for unity and the surge of nationalistic sentiments spurred on by the American-Spanish War. However, this transition might never have occurred had the Republicans clung adamantly to abolitionist principles or enforced rigorous anti-discriminatory laws in the South. As a result, a consequence, or perhaps a condition, of this alliance was the North's willingness to overlook the unconstitutional practices prevalent in the South. During this transformative era, the Supreme Court issued a ruling in 1896 that allowed racial segregation in railroads. The court's opinion, far from offering robust claims about the constitutionality of the Louisiana law under consideration, resorted to lower court precedents related to, but not precisely analogous to, the issue at hand. This technique served to buttress its stance. Moreover, the language of the opinion prompts one to question the sincerity of the justices, particularly when they suggest that blacks were themselves to blame for perceived inferiority, and when they gauged the reasonableness of laws by referring to mere custom. Justice Harlan's dissent, grounded in an originalist interpretation of the Constitution, wielded persuasive arguments, echoing those presented by Tourget, the lead attorney for Homer Plessy. In this essay, I will assert that a decision to ban segregation based on race would have aligned more faithfully with constitutional principles. Further, I will posit that many justices likely believed the original intent of the 14th Amendment encompassed the abolition of segregation in railroads and other public facilities. The Supreme Court's constrained interpretation of the 13th Amendment seems logical, given that its adoption served to terminate slavery and any conditions akin to involuntary servitude. The court recognized that the 14th Amendment aimed to shield the colored race from certain laws which had been enacted in the southern states, imposing upon the colored race onerous disabilities and burdens, and curtailing their rights in the pursuit of life, liberty, and property. This understanding seems justifiable. However, the court's task of interpreting the 14th Amendment to permit states to enforce segregated travel was considerably more complex. The opinion asserted that the enforced racial separation was not founded on the assumption that blacks were inferior unless the colored race chooses to put that construction upon it, considering that slavery had been abolished in the U.S. less than 4 decades prior. It seems disingenuous for the justices to cast blame on blacks for their perceived inferiority. I argue that this was a statement they could not sincerely believe in, given the prevailing societal view that blacks were inferior. Citing Roberts v. City of Boston, the justices regarded the decision to segregate schools as a valid exercise of state power. Though this may be true, the matters of education and railroad segregation differ significantly. For whites, the segregation of schools was of paramount concern. Genuine fears were harbored that white children might encounter blacks in unprotected environments, potentially leading to interracial relationships. Railroad segregation, on the other hand, would merely inconvenience whites during travel. Moreover, the ambiguous wording of the 14th Amendment did not necessarily demand school desegregation, but remained open to interpretation regarding railroads. A case could be made that public transportation was a right, unlike education, which could be seen as a privilege afforded by the states. Importantly, integrated railroad transportation had gained far more traction than integrated schools, with the latter being virtually non-existent. In some southern states, even trains had been integrated during the Reconstruction era. Other lower court rulings concerning railroad segregation were invoked by the justices to argue the states' rights to segregate or desegregate within their jurisdictions. However, all these rulings emanated from lower courts overseen by biased justices, and there was not a single instance where southern lower courts would willingly interpret an ambiguous constitutional clause against their state's legislation for the first time. Only the Supreme Court possessed the audacity to challenge custom in favor of law and provide a contentious interpretation without facing repercussions. A historical examination of Supreme Court decisions reveals a pattern where the court typically gives serious consideration only to its own precedents.
The court's repeated mention of social equality is also noteworthy. The justices contended that the government cannot and should not enforce social equality, even though it must treat all equally by law. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. Even if one were to concede this point, there remains a marked difference between allowing social inequalities to persist and enshrining these disparities in law. By approving such legislation, the court is not passively allowing the social status quo to endure, but actively engaging in differentiation among races. Their claim that the argument also assumes that social prejudices may be overcome by legislation exhibits the same flaw. Accepting that legislation may not overcome social prejudices does not automatically validate legislation that fosters, sustains, and crystallizes these prejudices. In analyzing the case, the court reduced it to the question of whether Louisiana's statute was a reasonable regulation, defining reasonableness with reference to established customs and traditions, a definition that ought not to have substantial legal weight. Harlan, in his dissent, clarified that a statute may be valid and yet upon grounds of public policy may well be characterized as unreasonable. Several instances of such statutes were apparent. Therefore, what appears in the court's decision is a disingenuous maneuver that fails to articulate the rationality of racial segregation in railroads, leaving unaddressed pressing questions like the potential for laws that could mandate racial divisions in housing and street usage. Throughout my reading of the court's opinion, I often pondered whether my discontent with their arguments stemmed from contemporary thinking. Perhaps the justices and the majority of the populace at that time genuinely believed in racial equality, save for certain social contexts. Yet examination of writings by Harlan, Turgeon, and others from that era reveals a keen awareness of racism's problematic nature. This awareness underscores the likelihood that the justices recognized their decision's potential to pave the way for the racially segregative policies known today as Jim Crow laws. Harlan's dissent is fascinating for his unflinching originalism, asserting, however apparent the injustice of such legislation may be, we have only to consider whether it is consistent with the Constitution of the United States.
So I doubt
He
not
appeared
it will continue
confident
to
that
be
the
for all
14th Amendment
time,
would forbid
if
segregation,
it remains true to
accusing
its
the
great
courts
heritage,
of overstepping by meddling in the
fast to
popular
the
will.
principles of
The appeal to
constitutional
originalism
liberty.
by Harlan, contrasted
But
with the
in
court's
view of the
reluctance to do
Constitution,
likewise,
in the eye of the
subtly
law,
implies a collective
there is in this
understanding
country
that an
no
originalist interpretation
superior,
would necessitate
dominant
dissent.
ruling class of
The court's
citizens.
interpretation
There
of the
is no
14th
caste
Amendment
here.
strikes me as disingenuous.
Our Constitution
To apprehend the
is
original intent
colorblind.
of the 14th Amendment, one
In my
need
opinion,
look no
the
further than
judgment
the
this day rendered
1875 Civil
will in
Rights
time
Act.
prove to be
This
quite as
act,
pernicious
adopted
as
in
the decision made by
1875, prohibited the denial of the full and equal enjoyment of public accommodations, privileges, or public conveyances on account of race or color. Given that a majority of justices, all but Harlan, that heard the Plessy case were also present during the cases concerning the 1875 Civil Rights Act, the inconsistency between the court's judgments on that act and on the Plessy case is striking. What then is the underlying reason for the court's ruling in favor of segregation? Is it inconsistency or a changing stance? The most plausible explanation seems to lie in the court's attempts to mirror public sentiment. The justice's decision in Plessy v. Ferguson appears to have been a hypocritical concession to the predominant belief that the North must tolerate Southern racism in order to forge broader unity. By examining this landmark case, we perceive a complex interplay of legal reasoning, historical context, and societal pressure, culminating in a ruling with profound implications. By probing the inconsistencies, both subtle and overt, we gain insights into the dilemmas and intricacies faced by the justices, recognizing the formidable influence of prevailing cultural norms on legal interpretation. The court's decision left a lasting mark on the legal landscape, reinforcing the doctrine of separate but equal that would continue to shape American society for generations to come.